Hello, my name is James Hunt. I'm the founder of Everyman Legal. I was at a crossroads in my career in July 2007, deciding what I would do next with my legal career. A client and friend of mine suggested that perhaps I looked at a virtual law firm, and I went to see one such firm. And whilst I liked the business model, I could see that there were potentially great advantages for me, the ability to work flexibly from home. I wasn't convinced that the culture of that firm was right for me. I wasn't happy that the systems and procedures in that firm would be suitable to the sort of work I wanted to do. So I decided I'd set up Everyman Legal and see whether I could create a really interesting virtual law firm that would enable me to practice law in the way I thought I wanted to practice. It's been a tough 4 years. We've been in the teeth of a really difficult recession, but I'm delighted to say that we are now building a team of really excellent solicitors, and I've got 3 colleagues with me today, and we'd like to have a discussion about some key issues affecting the legal profession. The first question I've got for each of my colleagues is the fundamental question of, is the business model of the traditional law firm really dead? And the really vexed question for clients and solicitors of billing, and can matters be billed on the basis of an hourly rate, or do we have to find different ways to charge for our services? And I'd first of all like to ask that question of Jocelyn Taylor, who's a construction solicitor, joined Everyman Legal 6 months ago. Jocelyn, what's your view on this tricky subject of fixed fees and hourly rates?
Well, as predominantly a litigator, I've been brought up with hourly rates, and that is the way in which the courts will obviously assess costs at the conclusion of a matter, both civil and criminal. But for some time now, my clients, and I have a lot of repeat clients, want certainty as far as I can give them of what a matter might cost them. And typically in writing to a client about costs at the outset, I will break the areas that we may have to go into tranches with a cost against each one. Sometimes it can be a fixed cost if it's a fairly predictable area. Sometimes it has to be within a range, and then sometimes it may be up to a certain figure, but with the agreement that if in fact the time I believe I'm going to have to spend is less, in actuality I'll charge the lower figure. And the watchword, I think, has to be for both clients and solicitors is keeping an eye on it.
Yeah, and do you think most solicitors adopt the same philosophy?
I'm not sure that they do. I mean, for many years now, I've also billed my clients on a monthly basis, so they know exactly where they stand on costs. I know where we stand on costs. And again, I can do the monitoring against what I'd said from the outset. And if I need to adjust it, I can adjust it, but giving them sufficient warning, because clearly they need to work within their own cash flow parameters. And I think it's that point that a lot of solicitors don't understand.
Edmund, if I could just ask you the same question. Hourly rates and billing, what sort of factors do you think are relevant when you're sitting down with a client for the first time? How do you evaluate that subject of charging?
It can be very difficult. I mean, I specialise in criminal and regulatory, and it can be difficult from the outset to actually assess what a case is actually going to take in the way of fees. There can be all sorts of unforeseen contingencies in relation to such a case. But what I try to do, first of all, is to set out very clearly the basis of charging, which still tends to be on an hourly rate, but also to try and package different sections of the case and try and quantify those in terms of cost. Now, that's not always easy, but you can, for example, obtain fixed fees or very accurate fee quotes from counsel and other third parties in relation to the case concerned, and that can make it a lot easier for the client. Certain minor matters can actually carry a fixed fee because it's pretty clear what the case will actually require in terms of work. For longer and larger cases, though, it can be considerably more difficult to actually assess what it will actually take in costs. And as part of that, as Jocelyn's just said, it's very important to actually look to the clients, see what the client's means are, see how they're actually going to be able to pay, what they can actually afford in relation to the case. Because particularly in relation to criminal and regulatory matters, there may well be substantial financial penalties at the end, and that also has to be factored into the economic equation generally and how the case is going to be progressed on their behalf. So not only are you assessing the risks of your own costs, but you're also assessing the risks of the litigation as a whole. So it's very much a balancing exercise, and the more information and the more actual communication you have with the client, then the better off is going to be the retainer between you and that client. So cost information is absolutely critical.
Rob Yonke, corporate solicitor. You're a corporate lawyer like myself. What are the challenges if you're doing a corporate transaction and trying to decide what you should charge?
Well, getting the work in the first instance on the basis that the price is going to be right for the client. And the great challenge is to package the work and quantify how much is involved in order to offer clients a fixed price for the packages that you identify, and to get that right. And the difficulty, I think, in many firms is that one gives estimates and then you're fighting on a back corner when the estimate, as it usually does, exceeds the amount that you estimated. And you write off a bit sometimes, but you also normally charge more than you estimated in the first place, which isn't good.
Why are estimates then always exceeded?
Well, because for the obvious reason that you don't want to go too high, otherwise you lose the job. Right. And I think in the model we have, where we do try to offer fixed prices, what clients like is the fact that you're sharing a risk with them. You do put parameters down because it's not a completely open-ended situation for us. But we've got to be very careful to put realistic parameters down, so that if we don't meet those parameters, then we can work on a supplemental fee arrangement with clients, which works because they know where they stand, they know the parameters that have been established and agreed, and they can see for themselves when they haven't been met. And if they haven't been met because of, through no fault of ourselves, they're very amenable to a supplemental fee. So you've got complete flexibility to quote a fixed fee. You've got flexibility to identify to clients what that is based on, and you've got complete flexibility to negotiate with the clients for supplement where it's justified or not. There's no pressure.
Yeah. And what about this question then of accountability of the individual solicitor to the firm for which he's working, and this requirement to deliver a set number of chargeable hours a day? What do you think of that, Rob?
It's complete freedom not to have that. And it's my sense is that with the traditional firm, of course there's a lot to manage. There are central costs which are high that need to be managed, and you're part of the organisation, so you've got to meet the requirements collectively as well as individually. So the real danger is that you're looking inwardly rather than outwardly in order to show that you're performing, whereas in fact the real indication of performance is getting the clients in and doing the work well and charging the fees that you said you would charge. So it's an enormous sense of freedom that I have now. Not that it's completely free for all. I still have to pay my way, but I've in a sense got my own business, Rob Yonke, working within the framework of Everyman Legal. And of course I'm interested in seeing the success of Everyman Legal, because that is the platform from which I myself can develop my own practice as part of it.
Thank you, Rob. Edmund, you're at the early stage of your career. How do you perceive the traditional law firm for the younger lawyer who aspires to be a partner? And how does that compare with the opportunities within Everyman Legal?
I think it's very, very daunting for young solicitors now in terms of a traditional law firm. I think it's extremely difficult. It's very competitive simply to start off at the bottom and actually even get a training contract. I mean, that's the first hurdle. But beyond that, I think it's exceedingly difficult, because what has happened in recent times is that with the recession and with tightening economic conditions and rising costs, what has happened is that partners have tended to try and ring fence, if you like, their number, and they've limited their number. They've tried to protect profits per equity partner, and what they have done is they have basically shut out aspiring and ambitious young lawyers who may be extremely capable and probably should in fact in reality be made up to partners, and certainly would have been in a bygone age, but because they want to keep their earnings high, they've basically shut those people out. And so very often there is this ceiling that young, ambitious and capable lawyers actually have, beyond which they don't feel that they're actually capable to rise. And the great thing about Everyman is you're not actually paying for partners' profits. What you're actually doing is, as Rob has so rightly said, you're basically making your own business. So you're actually operating from an extremely stable and progressive and helpful platform. That gives you the opportunity to actually grow. It actually gives you the chance to make of your practice what you will. And if you choose to work exceptionally hard, then you will reap the rewards of that. If you choose to adopt a more flexible approach or have a greater work-life balance, you can also do that within it. So it gives a very sort of flexible menu for an ambitious and talented young lawyer to actually join up, because they're not actually caught within the sort of traditional firm straitjacket, and there's also no need for them to follow a very traditional route towards partnership, probably where the doors are going to be shut to them anyway. So in fact, within the context of Everyman, I think it's an extremely positive development, because it actually allows these kind of lawyers who are probably developing their own followings, who are starting to make their names, to actually develop and to actually achieve something that they might not actually achieve otherwise.
Thank you, Edmund. Let me ask you another sort of provocative question. Jocelyn, would you say most law firms are well managed or badly managed?
But my own personal experience is that by and large they're very badly managed. And a particular concern of mine is that the tiers of management, generally solicitors, rather than anybody from outside, are so far divorced from clients and looking after clients that they truly do not know what happens. And that their measure of success is very much the sort of factors that we've talked about in terms of, KPIs in relation to the number of hours that are recorded, the number of hours that are then actually turned into bills, and various other straitjackets that they're putting young solicitors into. Whereas to my mind, that detracts from actually doing the client work and keeping the client happy and making sure we deliver what they want. And my measure of success is a client not necessarily being happy, because he may be in a position that he's got himself into where he's never going to be entirely happy, and we're doing damage limitation. But is sufficiently pleased with what we've managed to achieve that not only does he come back time and time again, but recommends us. And that to me is really what it should all be about.
Yes.
So that's my success.
Rob, a difficult question for you. Are traditional law firms badly managed?
Well, I think they have a lot to manage that they need not manage, in terms of some of the infrastructure that they've got and what they feel they need in order to provide the service. And that comes from having business plans which are themselves inflexible, so that when the business environment within which they work changes, they haven't got the flexibility to change with it, not as easily as we have at any rate. With the result that what they have to do is manage the situation in order to make the infrastructure work for them within the firm, rather than permanently for the clients out there. And they do obviously work for the clients, but sometimes one is dominating more than it should. But otherwise, I think I wouldn't say firms in practice are badly managed. I think they just have a different model, which makes it more difficult for them to provide a happy environment for all the employees and partners that they've got.
So do you think there's a cultural problem?
Yes, there's certainly a cultural
And
problem.
what is the nature of that problem?
Well, it's the this is the old solicitor talking, of course, going back to the 1970s again. But the culture today is not a corporate culture, in my view, at any rate. It's much more to do with individual performances. So the inevitable consequence of that is that there's competition both internally and externally. The external competition is healthy. What you're trying to do is get clients from other firms. The internal competition is unhealthy because it detracts from the first. And I think there's a great tendency nowadays for the internal competition to dominate because that is how people are judged, how they look on the firm's records, however they are maintained.
And why do you think that's come about, that cultural?
Oh, well, my jaundiced view is that it's to do with the way the legal profession is becoming more commoditised than it was, and being judged through ratings. And ratings do serve a purpose, there's no question about that. But if they are taken too seriously, and I think many firms do take them too seriously, the danger is that they are modifying their affairs, managing their affairs in order to deal with the ratings rather than what is really fundamentally best for the firm and their clients.
Yeah. Edmund, what about you? Do you think law firms are badly managed? Do you think they have a culture that's conducive to providing good legal advice and a happy environment for the lawyers who work for them?
I don't. I feel quite strongly that solicitors are trained to be solicitors, and they are not necessarily business people, and they certainly are not necessarily good with the chief assets of any law firm, which are its people. And even though some solicitors may fall very naturally into managing a law firm, I think an awful lot don't. The Law Society, I think, has tried to address the deficit of management skills amongst solicitors by putting on making mandatory the management courses. But I think there are an awful lot of solicitors who fail to manage their businesses well, and far better actually being lawyers rather than business people. And I think that's a fundamental misconception that an awful lot of traditional partners have, that they think that they know how to manage people, that they know how to organise businesses, but actually they don't have the first clue about what will actually make for a happy place to work and to be honest, to actually be economically successful at the same time. Very often the two go hand in hand. So I'm pretty scathing about the simple fact that somebody's a solicitor makes them a manager. And I think that the more delegation of administrative and managerial tasks that can be given to people who actually know under the appropriate supervision, the better for a law firm generally. Of course, in relation to Everyman, you are very much your own business person, but then of course there is the accountability. And so you are learning all the time, and so therefore you are far more efficient because you are the one who are reaping your own rewards, and that I think is a real sharpener for any form of management. And the Everyman model gives the flexibility for people to manage in the way that is most effective to their particular area of work, their particular area of specialism, and that is a vast improvement on, I don't know, somebody in property, thinking that they know what the hell goes on in a court of law, because very often they don't have the first clue, and therefore they cannot effectively manage that, and they certainly can't exploit the business opportunities that may actually be available in that particular area.